It is my pleasure to introduce Emily O'Neill, the Technical Services Librarian of Deschutes County Library, as our speaker today. Oregon Libraries Association's Intellectual Freedom Committee, where she served as chair from 2021 to 2024. She's also been trained by the American Library Association's Office of Intellectual Freedom via their For Librarians program, serving as the intellectual freedom trainer for the state of Oregon. It's really kind of a tongue twister, but anyway, most importantly, which she put lastly, Emily was awarded Oregon's Librarian of the Year for 2024 for her work protecting intellectual freedom across the state of Oregon. Welcome, Emily.
Thank you. I don't even know if this is on, and can you hear me?
Yeah.
Okay, okay, so I'm just gonna ignore that. Man, you guys do incredible work. That was very impressive, and I just am in awe of you, so I hope that you all get some good information because you're doing really incredible work with advocacy in our community. Today I'm here to talk about intellectual freedom, and it is my most favorite topic. So I hope that I can talk passionately about it because it is certainly something that is very close to my heart. So who am I? As mentioned by Carol, my name is Emily O'Neill. I work for Deschutes Public Library as the Technical Services Manager. I hear an echo.
I did.
Yes. I think it's good to have that here.
I just want to make sure everyone can hear, can get distracted.
Yeah.
Are we good?
I think it's.
Okay. Are we good? Okay. I am a bit of an expert on this in the state of Oregon. So as mentioned, I have chaired the Intellectual Freedom Committee through the Oregon Library Association. What that committee does is that we help support libraries and schools when they have an intellectual freedom concern. So we are the people they call when they get a book challenge or any sort of First Amendment freedom of speech concern, so that we can help them walk through that process. That's the moments of panic. We also are there to help proactively help them have policies and processes in place so that they don't have that moment of panic. And because of that work, I mentioned, I am your Librarian of the Year from the state of Oregon. This presentation, I'm going to talk about the law a lot. And so one thing that is legally required of me is to let you know that I am not a lawyer and that this is not legal advice. So what I can share is legal information. So I'm going to touch on the foundations of these topics, but if at any point you need actual legal consultation or advice, you have to contact a practicing attorney in the state of Oregon, preferably a constitutional lawyer and not, a real estate lawyer. So the Law for Librarians program is part of how I have this foundation. So that was provided from the American Library Association through their Office of Intellectual Freedom. And essentially they brought in a wide swath of lawyers that are experts in this topic, from Harvard Law, folks that have actually combated Moms for Liberty in the state of New York and have won those cases, a copyright lawyer, and then actually ALA's own contracted attorney who provided the training that then I get to bring back to the state of Oregon. And I have a responsibility to share it as widely as possible. So thank you for helping me fulfill that responsibility. So what is intellectual freedom? So I'm going to read the really boring, often wordy definition first, and then we'll go into what that actually means. So the definition is that intellectual freedom encompasses the freedom to hold, receive, and disseminate ideas without restriction. It is viewed as an integral component of a democratic society. Intellectual freedom protects an individual's right to access, explore, consider, and express ideas and information on the basis of a self-governing, well-informed citizenry. Again, so wordy, which I think is very lofty and very idealistic, but we need to know exactly what we're talking about. So I like to define it as the reverse engineering of those words. It is the freedom of your own intellect. It is your unrestricted access to information and ideas. It is your freedom to read and to learn and how you choose to learn it. It is your freedom to take in information and how you ingest it and what information you choose to bring into your own intellect versus what is required of you. But the most important part is that it is a First Amendment right. It is tied directly to the United States Constitution. And people get confused about how this is tied to your First Amendment rights. So let's talk about that. So this is your rudimentary civics class. Probably you all don't need this, but I just want to lay some foundation. So we'll go somewhat quickly because I know I'm talking to experts in the field on this. So under the United States Constitution, of course, there are the Bill of Rights. And you all know that the Bill of Rights is often referred to as our civil liberties. We know that the founders of our Constitution would not sign the Constitution without protecting what it meant to be a human being in this country. And that's why it's called your civil liberties. These are your rights as a human being in this country that cannot be taken away either from the government or from each other in the way that we interact with one another. They were very purposeful in how they wrote that Bill of Rights. They put a lot of things, for example, under the First Amendment, and that's because it is the most important. It was the first priority to protect, and so they put everything that was number one under that First Amendment in the Bill of Rights, which is why there's so many things in it. It's your freedom of assembly, it's your freedom of press, it's your freedom of religion, and it's your freedom of speech. So we're specifically talking about freedom of speech. And people, again, often say, well, how does this tie? You're talking about freedom of information. How does that tie to freedom of speech? So since the adoption of our Constitution, so hundreds of years, anytime there's been a legal question of what that Bill of Rights means, what that amendment means, it goes through the court systems. And as it goes through the court systems, eventually leading its way up to the United States Supreme Court, precedent is created. So that means that a judge has ruled on it and has said it means blank. And oftentimes in that ruling, they'll include things like a court opinion that will help define what it means the next time this question comes up. So over hundreds of years now of the Supreme Court having these cases brought forward, we narrow in what freedom of speech means. So through that court process, courts have held that in order to have freedom of speech, you also have to then have freedom of informed speech. In order to have freedom of informed speech, courts have held that you have to have freedom of information. In order to have freedom of information, you have to have freedom of free access to that information, which is now why libraries, the place where you get free access to information, is directly tied to your First Amendment right of freedom of speech. The court case that we look at currently that is the most recent precedent on the matter is the Kramer versus the Bureau of Police for the town of Morrison from 1992. And the court opinion said in that courts have held that libraries are the quintessential locus of the receipt of information according to the Third Circuit Court of Appeals. Okay, so we know that we are tied to the Constitution. We are a government agency that now has been directly tied to a requirement to uphold the United States Constitution. So that means we are now what is called a public forum. So there are three types of public forums that government agencies fall into. The first is a traditional public forum, which is what you all are planning on Saturday. Your demonstration and your march would be considered a traditional public forum, and that's often places like Parks and Rec. Anything outside of walls is typically a government forum, a traditional public forum, which has the most broad definition of freedom of speech. Basically, as long as you fill out, the appropriate paperwork with the city, you can pretty much say anything that you want to say in that traditional public forum with almost no restraint. And that's, again, your freedom of assembly, also tied to the First Amendment. Libraries fall under what is called a limited or designated public forum. So what that means is that in order for us to be able to uphold that constitutional requirement, we are allowed to put in certain restrictions on our service. But those restrictions can only be one of three things. They can be a time, a place, or a manner restriction. So what that means is if I did a time restriction, that is our ability to say that the library is not open 24 hours a day, right? Because in order for us to have librarians that serve you with the information needs that you have, we also have to follow other laws, BOLI and OSHA, and they get to go home, right? And so we don't have the library open 24 hours a day so that we can be present to your information needs. So we are allowed to set a time restriction on that building, even though that building and the information in it is yours. We are allowed to put a place restriction. So an example of that is that entire building, though it's yours to fulfill your information rights, in order for us to get that material back out to the shelves. So all of the awesome books that you're checking out goes through a staff space, and the staff has to be able to check that in and sort it and get it on carts so that we can quickly get it back out to you all to browse and absorb. So if members of the public are browsing our shelving carts while we're trying to sort it, that would be a disruption on service, and it would be an infringement on everyone else's rights, because it means that we're not getting that material out to you as quickly as we otherwise could have. So we're allowed to say certain parts of the building are staff only. That would be a place restriction. And a manner restriction is our code of conduct. So those are anything that you all do in our spaces that could feasibly infringe on the rights of everyone else in that space. So what that looks like is, for example, we say that you can't blast a boombox in the adult nonfiction when people are trying to research and read, right? That noise in that space impacts the use of that space for everyone else. And therefore, that's an infringement on the rest of the community. So we are allowed to put manner restrictions. What we are not allowed to do is that we are not allowed to, at any time, put in a value-based restriction. And we'll come back to that. And actually, no public forums can do that, but we'll come back to that. And then the last is a non-public forum, just to wrap it up. That's going to be places like your fire departments, where really they're there to serve you as a government, agency, and make sure that you're safe in your community. But really, you're not allowed to just wander around the fire department, right? Like the entire place is there so that they can go out and do a job. And so it's not a place where you're really exercising any sort of right, even though it's a government agency. So universal rights that apply to all government forums is that no government agency can engage in viewpoint discrimination. So I cannot, in that time, place, and manner restriction, I cannot say certain people aren't allowed in the building, right? Like that would be a viewpoint discrimination. Or I cannot say we are only going to buy materials under this one particular point of view. That would be a viewpoint discrimination. Any regulation of protected speech must be a reasonable, content neutral time, place, or manner of regulation. And the reasonable part's important, right? Like I mentioned, we don't have to be open 24 hours a day, but we do have to be open to the public. And so we can't say the library's only open for an hour on Sunday, right? Like that would be unreasonable to the community for their information needs. And then all government agencies are subject to laws barring employment discrimination, and an agency cannot discriminate on the provisions of services to the public. There are protected classes in law they're called anti-discrimination laws, and those protected classes are things like race, religion, sex, sexual orientation, gender, and a disability would be another. And among those, you cannot set any policy that would be seen as discriminatory to government protected classes, and that is both federal and state law. So with that, we have our parent organization, the American Library Association, and the American Library Association is similar to the American Bar Association, right? We are a profession that are master's level librarians, and we have guiding principles that we have to follow as part of our profession of librarians. And among those guiding principles that are provided to us from the American Library Association is our Library Bill of Rights. This is equivalent to the first do no harm for doctors. And these are the things that we have to do to uphold our profession from our parent organization of the American Library Association. So among the Bill of Rights are that materials are provided to all. Materials represent all points of view. We challenge censorship. We are open to all. Meeting rooms and exhibit spaces are available to all equally, and we protect the privacy and confidentiality of patron information. Patron information includes your circulation records, right? Because if you knew that your circulation records could be disclosed in some way, there is a possibility that you would not absorb information that you otherwise would have. And so that is really important to us to make sure that you know at no point is anybody ever going to get your circulation records. It's actually also written, by the way, into Oregon privacy law that circulation records are protected. ALA also provides us with additional statements. These are much longer, but certainly worth a read, called the Freedom to Read and the Freedom to View statements. Again, they're pages long, so I'm not going to present on all of them, but here are some of the points in that really stand out for me. So the first is that we trust Americans to make their own choices on what they choose to read or watch. So knowing that we believe you pick what you want to read, right? That is fundamental to you, that is choice reading, and that we will uphold that. We trust Americans to recognize propaganda and misinformation. Doesn't it? Every time I read that one, I'm like, is that true still? But the foundation of that is that libraries are here to help you if you're unsure, right? That there is a free resource that exists in your community for you to bring information to and say, is this misinformation or propaganda? You help me decide, right? But we are not going to tell you. We're here to give you ways to look at information in an objective way. So things like checking your sources or making sure that that's a real URL or checking the background of the author. We're here to help you so that you can decide whether or not that is misinformation or propaganda. We do not believe that Americans would sacrifice their right to press or information in exchange of a protected worldview. So one of the things that we hear often, and we are going to get into the book challenges because I know that's why you're already all here, is this idea of I'm here to protect the kids. But we believe that actually we would not sacrifice our access to information, our First Amendment constitutionally protected right for a protected worldview. That is up to a parent to decide or up to that family unit to decide. It is not up to the library to decide what your protected worldview is, and that we believe that you all ask us to do that. We believe in the free expression of, we believe Americans favor free enterprise of ideas and expression. We are an opinionated group, and we like to be able to share our opinions, and we believe in your right to do that. So if you don't like materials in the library, we do believe that you get to have the right to tell us whether or not you found something that fits your worldview or not. That is your right. That is also part of freedom of speech. And the last, which again really gets down to the book challenges as we get there, is that we defend the constitutional rights of all individuals, including children and teens, to use library resources. So one thing that gets very confused is you don't age into your constitutional rights, right? This is not something that you turn 18 and all of a sudden you have freedom of speech. It is, again, your civil liberties that were given to you at birth as a living being in this country, which means that it is our responsibility to protect the information rights of everyone, including children and teens. So let's talk about children. So legally, back to our legal precedent, legally, we are held to what is called in loco parentis, which is that a library does not serve in replacement of a parent. We are often being told it's your job to protect the kids, it's not our job. And actually legally, we are not allowed to do that. The only person that can protect that particular child is that particular child's legal guardian. So when we push back on a parent and say, it's really up to you to set the reading standards of your own family unit, it is up to you, because that child has rights. And until that child ages out while they're still a minor, the only person that can infringe on that child's rights is that child's legal guardian.
Do legal guardians have the right to see what their children have checked out?
Not necessarily. So with a public library, again, that's circulation records are private, regardless of age. However, if the parent is associated with that account, so when that child sets up for an account, you can have it linked to a parent. If that has happened, which almost all parents do it, right? Because a child is rarely signing themselves up for a library card. It is basically a joint account. So it's both the parents and the child's. So that's just a question of like, if they're linked, then they can. Questionable practice, by the way, something that I pushed back on at our library, but for now, and that's because there's a financial element. If that child were to lose the materials, we can't hold a child financially liable. And so it's the parent that's taking on the financial element of those lost materials. Now at a school, even more questionable, because at a school, again, there's state privacy laws that say that you cannot dispose circulation records. A parent is not attached to that record at all because it's part of their student record and their student card that you get as being part of a public school. However, there's FERPA, and FERPA says that you have access to educational records, but there's not been any law or any legal precedent that defines whether or not a library record is considered educational records. So every school does that a little different, and I'm waiting for the lawsuit that will answer that for us. Yeah.
What about porn? Can libraries restrict?
Oh, we're gonna get to that.
Porn access?
We'll get to that. We're getting there.
Okay.
Save that. Perfect timing. Thank you for the segue. So there's a question of pornography. So pornography is not a legally defined term. And as a matter of fact, courts have held repeatedly that is deeply subjective. What one person finds pornography, someone else may not find pornography. A great example is erotic fiction, like erotic literature, or even just romance books. Some people will find romance books deeply pornographic, and some people are like, that's my genre, I just read everything. And so courts refuse, actually, to define pornography. So overall, the short answer to that is that it depends the answer, but the short answer is that pornography is protected speech, and you do have a right to absorb that under what you don't have a right to do. So the questions are, freedom of speech is not absolute. We've all heard that. There are certain things you cannot say. What are those things? So I'm gonna take us through that. And actually, ultimately, the courts have held repeatedly that they try and have the fewest restrictions possible on freedom of speech because it's in the First Amendment, it is the most important. So even though we may find things really nefarious, by and large, the courts have held you have a right to do it. Here are your exceptions. So the first is obscenity. So courts have created a legal definition of obscenity. And they have a test that courts must follow in order to find something obscene. That test has two really important elements before we even get into the prongs of it. The first is that it can only be done by a court of law. So it's a legal test that gets processed through a court proceeding. So only a judge or jury would be able to be the one that processes this test. I don't get to tell you if something's obscene. Somebody in the circulation desk doesn't get to tell me something's obscene. Somebody making noise at a school board or board meeting doesn't get to tell me something's obscene. The only person that can do that is a judge or jury. The second part of that is that all three of these elements must be true in order for something to be found obscene under a court of law. So these are and statements, not or statements. So the first is whether the average person applying contemporary community standards would find that work taken as a whole appeals to indecent interests. So there's a lot of important elements in that. The first is contemporary community standards has been legally defined as a nationwide standard. So it's not going to be based off of that one particular school district's needs or even just Deschutes County's needs. It's going to look at contemporary community standards across the nation. And when they're looking at that, they're saying, have other schools allowed that book to stay? Have other libraries allowed that book to stay? And if they have, then the community overall has said that it has value. The other part is work taken as a whole. It says taken as a whole twice in this definition because it specifically is saying not bits and pieces, not parts taken out of context. And then the entirety of that work is of indecent interest. So that's prong one. And whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the state law. So this tells us that the courts don't find vulgar language obscene. They don't find violence obscene. It is only obscene if it's about sex. So if they're coming to us and saying, well, it says the F word 37 times, the courts aren't going to care about that. Unless it's sexual conduct, it would not pass the Miller test. And then the third, in addition to that, is again the work taken as a whole, which is why it's so important they bring it out twice, lacks any serious literary, artistic, scientific, or political value. That work has no other value to the community in any fashion than it would be considered obscene. People often ask, has anything ever been found obscene? So I asked the lawyers that trained me in the Law for Libraries program, and they couldn't name one.
Is that right?
Yeah, and I asked even, I believe there were court cases about, Playboy and Hustler and Penthouse, and when those have gone up, they have passed the Miller test as non-obscene, as freedom of information. So then you take that Miller test and you apply it to, again, this concept of kids, right? That we have a responsibility to the information that children, are exposed to. And again, the courts have helped us define what that material can be. And so they take that Miller test, those same three prongs, and they it's now called the harmful to minors test. And they apply that under, is this harmful to a 17-year-old? And it's specifically a 17-year-old because minors is defined as anyone under 18. We don't have brackets in the law of 0 to 5, 5 to 10, 10 to 17, right? They're all one. We don't have minors A, B, C, and D, or 1, 2, 3. It's all one bucket. So if you were to say this material is inappropriate for a 7-year-old, but is probably fine for a 17-year-old, but then you removed it, you've infringed on the rights of everyone that it actually is protected for. And so the court would look at, is this harmful to anyone 17 years old? So that's obscenity law. The rest of the things that you cannot say under the First Amendment. So the next one is child pornography. So again, there's no legal definition of regular pornography. Too subjective. If we're gonna go to obscenity, if that's the question. But child pornography is of course unprotected speech. However, there is legal definition of what child pornography is. So again, certain prongs that must be true in order for something to be defined as child pornography. The first is that it must be a visual depiction of of sexually explicit conduct involving a minor under the age of 18. They define those visual depictions. So the definition of the visual depiction is a photograph, a video, a digital image, underdeveloped film, computer-generated images that are indistinguishable from an actual child. Courts have specifically said that visual depictions do not include illustrations, drawings, or passages in books. So again, if the question is, but they talk about this in a book, or there's a graphic novel with an image in the book, courts have specifically said that illustrations and passages in books do not fit the definition of child pornography. The other things that you cannot say. So you cannot say defamation and slander, which is actually very interesting as we move forward to the challenges that happen, because librarians are being told that they're pedophiles and groomers, and they're being told very negative, very terrible things. And actually, that is illegal. So you cannot knowingly defame somebody's name under the court. So should a librarian experience that, I often tell them it's a really good time for you, in fact, to get a lawyer, because they cannot say that about you under your profession. The next is false advertising, which doesn't feel like it counts in book challenges, but it actually is very tied. So where this applies to book challenges is people like to say things are age inappropriate. That's inappropriate for a 12-year-old. When a book is written, the author themselves decides who they wrote that work for. It's called the intended audience of the work. And that is part of what is given to a publisher when they pass that materials on to be published, is I wrote this book for this age bracket. That publisher is then, their publicist is probably gonna say, hey, yes or no. So just a general agreement, disagreement. When they get into alignment, then that book gets what's called an advanced reader's copy. And that advanced reader's copy goes out to educators, librarians, other authors, other publishers across the country, and they get to read that for a variety of reasons. Sometimes they're proofreading and editing, but one of the reasons is that they're making sure that that intended audience of the work is in alignment, and they will give that information then back to the publisher. Then that publisher is going to take that information and send it to their legal team, because when they produce that book, there's going to have a spot on it that says this is intended for ages 11 to 17, and they don't want to get into advertising when they put that on a book, when they put that in a book review. So when librarians and libraries put a book in a certain age bracket in our collections, it's gone through an objective process and a legal review process that book does fit that age bracket. The last two are fighting words. This is the big one that people often hear about, where you say you can't yell fire in a crowded movie theater. It's because if you were to do that, there's a possibility that you could hurt people. That crowded movie theater often has steps, and it's dark, and people are panicking, and you could fall and either injure yourself in a fall, or people could actually trample you, and you could either get seriously injured or die because somebody said something that created that physical harm. So that would be fighting words definition, and you cannot do that. And then the last is national security via the Patriot Act. Even more so now, the federal government can redact anything that they want under the umbrella of national security. ALA helps us understand all this, so I highly encourage going to what's called the interpretations of the Bill of Rights. They take you through a variety of scenarios, like what about access to materials in prisons, or what about internet filtering? So if you have any specific questions, I highly encourage you to look at this, because it takes you through some pretty interesting scenarios. So now we talk about what is censorship. So we know we have this right to information, but what does that mean when it's been infringed upon? So the definition of censorship is that your access to something that was freely available to you has been restricted in some way. That's the actual definition of censorship. So you often will hear, it's not a book banning, you can still buy it on Amazon. Or it's not a book banning at a school library, you can still get it at the public library. But what we're not talking about book banning, we're talking about an infringement on your First Amendment right, which is called censorship. Banning is the removal of the material fully from the library, which would be considered censorship. You had access to it and it was removed. But ultimately, censorship is the restriction on that access. So under this umbrella, it's not banning you can buy it at Amazon. Well, Amazon can choose whether or not they want to sell it because they're a private corporation. But you're also now saying that it's not immediately available. You have to wait for it to come in the mail. What if I needed it today? That's a restriction on my access. But even more is a financial, right? Like we are assuming that somebody has the financial means to exercise their freedom of information and their freedom of access to that material. Yeah.
Would banning or restricting the use of cell phones in libraries and classrooms be considered censorship or in violation of some of the First Amendment rights that you're talking about?
That would be a really good question for a lawyer. I haven't seen that case come up yet. I think if they were going to look at it, I think they would be looking at, is that cell phone being required to access their information need? So are you saying, kids, pull out your cell phone and pull up this article? Or are you giving them access to that information via, kids, we're gonna go to the library and use the internet there and grab that information. So I think it's gonna be about, how did you tell that child to access that material, and did they have no other option? And then if you took it away, certainly I think that would be a case. So challenges are when somebody asks a library essentially to infringe on your rights. So the most common is, I'm asking you to remove it. But I want to clearly define that there's a lot of different ways that community members ask libraries to infringe on your rights. So these are what I call my R's of censorship. So I'm going to take you through each of them in a little bit more detail. The first one is restriction. So saying, I don't want you to get rid of that book, but can you make sure that like you only let people check it out that have an adult's card, right? Like saying like you can keep it, but like put a restriction on access to it by age bracket. Again, a library does not serve in local apprentice. We cannot say whether or not a youth card or an adult card can check that out. The only person that can decide whether that youth checks out that material is that youth's legal guardian.
Is that in the school library also?
Yeah, because all of the materials in the school library would be, and schools are complicated, by the way. So schools that will have a selection criteria that under their collection development librarian and collection development policy. And within their collection development policy, they're typically including at least 3 things, often additional things. But among those 3 things is that the materials in the school library support the educational requirements of the school. So what are the goals and objectives of the school, and are we buying materials that help support that? Thing number 2 is we encourage critical thinking skills and choice reading materials. So making sure that there are choice reading materials for students in schools. And then the last one again brings us back to that intended audience, that we are selecting materials that fit the intended audience of the school. So if those 3 things are there and they're in the library, if a parent were to say, librarian, I want you to make sure that my kid doesn't check this out, it would actually be up to the parent to say, child, what have you checked out? Here are the rules and parameters within my household that I'm asking you to follow. The second one, redaction. So This one's actually, I have a legitimate story on this one, which is always makes me laugh. So redaction is, I don't want you to remove it, but could you just black out all the dirty words? And the funny part is, not the library here in Deschutes, but my previous organization, we had an entire series of books that somebody had gone through and whited out all the dirty words, and we had to rebuy it. So people do try the redaction option. The third is relocation. I don't want you to get rid of it, but can you just make sure that that book that was intended audience kids gets put in the adult parenting area? So in doing that, we are making it more difficult for the book that was created for this age bracket to find the material that was intended for them. And so you have now put a barrier in access to information because that child is less likely to find the work that was intended for them. I don't want you to get rid of it, but can you just put a rated R or like explicit content sticker on the book?
Well, that'll get their attention.
It certainly will. And it in some ways would convince people to not check it out. So for example, if you said, I just want you to put a rainbow sticker on the book, but the individual hasn't necessarily come out to their family, or it's not safe for them to come out in their family, or they don't want to read a book on the city bus with a rainbow sticker on it, they're gonna choose not to check it out because you put a label on it that would hinder their access to that information. And then the last is the removal. So I want you to get rid of the book. And that's the one we most often hear about. But again, we're not talking about banning and removal. We're talking about censorship and a restriction of your access to information. So what is the impact to the community? So this is what you're here for, is how much is this actually happening in Oregon? So the first is that when libraries do this incorrectly, and sorry, that's really light, but they're getting sued, and not small lawsuits. There's one in Florida that is backed by the ACLU, the publisher of the book, the author of the book, and PEN America. So imagine a library trying to go up against that. And it's happening all over. ACLU has been suing in Arkansas, PEN America again in Florida, ACLU in Missouri, Wisconsin, Texas. PEN America has been doing it in New York. There's a new one in Iowa and Idaho. So if libraries do this, there's a really good likelihood that on information, rights to information, lawsuits, and they are by and large losing. When they've gone to the courts have continued to uphold the First Amendment rights, and libraries have very expensive legal fees that they have to pay. So here are our numbers. So I want to take us through a little bit of what these numbers mean before we dive into them. So the first is the number of incidences. So what that means is how many challenges, and this is a nationwide statistic, by the way, provided by the American Library Association. So this was last year. By the way, we'll get new numbers in April, like probably in the next week or two, because they put out their data for the past year in April. So this is about a year old at this point. So in 2023, there were 1,247 unique incidences where somebody has asked the library to restrict access in some way across the country. Within those incidences, there have been over 4,000 titles, which tells us that people are challenging materials in large numbers. It's not a one for one. It's not one incident, one title. It's one incident, sometimes 10 titles, sometimes 32 titles, sometimes 800 titles. And imagine a library trying to manage that. And then those are the unique titles, sorry. So the individual bibliographies of a book. So like this particular book has been challenged, 4,000 times. Out of that title, let's say it's Flamer, has been challenged up to 9,000 times. So it's the same titles that are getting challenged over and over and over again across the country. And I just shared that. So what are the titles that are being challenged and why is this a concern? Well, these are the top 10 and actually there's 11 because 7 and 8 are tied. They are almost all materials by or about LGBTQ lived experiences or BIPOC. There are almost no and have been almost no challenges that have met the top 10 in the last 5 years that aren't about the two most impacted, least seen members of our community. So it's really a conversation of I don't experience and the lived stories about our least seen members of our community that people are having concerns about. It's not concerns about, they'll say it's sexual content. It's only one type of sexual content. And sometimes it's not even sexual content. One of the top 10 from about 3 or 4 years ago was Entango Mayuri, which is a picture book about two penguins that are of the same gender that raise an egg together. That's not sexual content. But the fact that it was the two penguins of the same gender that was the actual problem. And it's a picture book and it's a true story. So here are our numbers. So since when did we start to see this uptick? When did we start to see this rise? It was right in 2020, and our numbers have doubled year after year. And at this point, we're up 38% of unique titles since 2021, when we really started to see the uptick. People will often ask, why? What happened? Well, you all know what happened in 2020. So what happened in 2020, I think a few things. So one, we had a very contentious political presidential election. And at any time we have a highly contentious presidential election, our world is divided. And we get divided in very polarizing ways. In addition to that, in 2020, we had the murder of George Floyd. So among those polarizing things was this idea of whether or not there's police brutality, whether or not we're a racist society, whether or not we have systemic racism, and the world is starting to really look at this group of people that is part of our community and saying, don't talk about your lived experience because you're saying it wrong. And now they're starting to come out about books about that lived experience. We also had more and more individuals feeling empowered to share their lived experience about being LGBTQ. And again, people saying, that doesn't fit my worldview. I don't like that story. And so I'm gonna challenge. I see it come up. And then we had COVID. So people are just more aware of the types of education, the types of materials that are being shared in schools. And that just created this mega storm of, I wanna control the narrative, I wanna control the information. And so I'm gonna challenge it in all the ways that I can. So the heat map is important because I think that we on the West Coast like to think West Coast is the best coast, and that this doesn't happen here. And I want to make it clear that this is happening here. Oregon is not particularly light on this heat map, and it's rising. What was that? You can see that Florida are places where this is happening at an extreme level. They have actually passed laws and legislature there that has been very contentious. I had mentioned the 800 books at one time that did happen in Texas. And in Florida, they were told they needed to remove, I think it was something like 300 books from every single school in the entire state of Oregon through that legislature. I'm a native New Mexican, so I can tell you the reason why New Mexico is light is because they're not reporting. And I'm allowed to say that. Also, it's a very low populated state, so like there's just, it might be big, but there's just not a ton of people in that large geographic area. Here's for Oregon. So again, looking at the number of challenges and the number of items, again, seeing a huge spike in both the number of challenges and the number of items. I want to call out the number of items because again, the idea of materials getting challenged in large lists is happening here. What happened in 2023 is Canby School District had, I want to say it was 39 books challenged all at one time. Many of those did ultimately have restrictions put on them, and one book was removed from the school entirely.
Challenging.
We'll get to that. That's a great question. We're almost there. Question of, is this only happening in one type of community across Oregon? So the first is, I think, a misconception that challenges are only happening in schools. And so the pie chart on the one side, the green is anything that happened in a school last year, and the yellow is anything that happened in a public library, and they're the same number. So we are seeing challenges happening at both access points, which is interesting because sometimes when we have challenges at schools, they'll say things like, well, you can get rid of it here, they have access to it at the public library, and then they're immediately challenging it at the public library. So it is, again, it's a controlling of the information, a controlling of the narrative. It is not about an access point. It's a, I don't want that story told.
What's an example of an academic library versus public library?
An academic library would be like the University of Oregon or COCC or OSU. So the beyond K through 12, anything about that. The other question is it happening only in rural areas or urban areas? And rural seems high unless you add urban rural together, which, by the way, Deschutes County is considered urban rural. And then theirs are equal again. So between rural and urban rural, it's the same number. Again, the types of words on the challenge materials is very interesting because though all of the books, as we saw on our top 10, are about two particular demographics, they're not always saying that on the book challenge. So sometimes they're specifically saying, I don't like LGBTQ materials, like in 36 of the challenges that happened last year. But by and large, they're saying things like, it's sex, it's nudity, it's unsuited for the age group, or they're just leaving it blank. And so what happens for us is that it's through the interactions that we realize that this is from a place of bias rather than the actual words that they're putting on the challenge forms. And then again, challenging books. I'm going to give you some statistics and then we're going to start to get into examples. But one of the things that I want to make really clear, and again to people that are very interested in elections, is that it's not just our family members. So we do see family members at 21 of the challenges, or a patron if it's at a public library. But there's a ton that are coming in, and even more this year when these statistics come out, I think it's going to skyrocket, that actually have nothing to do with that community. So a lot of schools are getting challenges just from community members that don't have students in the school. Organized groups. So I mentioned earlier, like Moms for Liberty is very organized in their challenge, their challenge processes, and their that they give out to their members and say, challenge it this way at this library, and they're just formed. I mean, I can't tell you how many I've seen. They're literally the exact same thing, and they've just come from an organization that says, do it this way. And there are times that it's coming from even our administrators and our elected officials. And I'll get into that, but especially our board members, when a material comes to them, they may or may not be willing to uphold intellectual freedom if they feel like it's going to impact their ability to get reelected, or if they themselves fall within that mindset. And we'll talk about a couple examples here. So now we're getting into examples. So what are the types of materials that are getting challenged? So by and large, it's books, passages, a lot of graphic novels. So again, there's this feeling that like if there's this visual element to it, it somehow is worse. It somehow needs to be held in a different regard. And so a reminder that visual depictions, illustrations or drawings, and they, again, specifically the definition of child pornography, and they don't include passages in books. So yeah, there are some graphic novels out there with some very striking imagery, but it is protected speech. And taking the work as a whole, and I've read them, it's my job, they do have value. and that they're gonna come back to that Miller test is certainly, and we don't take things out of context. So an example that happened, this was in Enterprise Public Library. Just a reminder that it's not just books and graphic novels. There was a sex ed pamphlet that was free distributed from a nonprofit in town that shared sex ed resources and support for LGBTQ teenagers, and that was challenged at the Enterprise Public Library. It was removed because somebody threw them all away, but they did bring some additional back in, and the library did end up keeping that pamphlet. Again, the challenges are by and large about government protected classes. So here's an example that came out of Helix Charter School in 2023. In that, again, we're seeing lists of books. So at that time, 18 books were challenged in one particular form from the teacher's classroom library. Of the 18, 11 were considered, were taken. They were removed from access to both that school library, the classroom library, and the school library. The question of, if you go back to the Bill of Rights, we have an information responsibility to all of the ways that you receive information, right? We're not just receiving information from our books. We receive information from programs. You're learning information from me right now, or our bulletin boards, or our exhibits, or our book clubs, right? There's lots of different ways that people receive information, and all of that still has to be protected under our First Amendment rights and under our requirement as a library to uphold that. So some examples where challenges have happened that aren't about the books that we are still needing to protect in Klamath County. So Klamath County Public Library, this was just last year, they had a book club that was put on by the public library, and it was called their Social Justice Book Club, and it had been happening for years with no concern whatsoever. And then they had selected a book that was titled No More Police, and one of the county commissioners was the former chief of police. And so he found out about that, and he said, shut it down immediately. And ultimately, the outcome of that is that they said the library cannot do any political programming. Well, again, that's not a content neutral stance, and actually we have to share information about politics. That's one of our most important aspects of sharing information, as long as we're presenting it in an unbiased and neutral way. And so we had a lot of back and forth. Ultimately, they stood behind that they would not allow the library to move forward with the Social Justice Book Club, but that it could be hosted at the library by library volunteers. So the book club did come back, but with some caveats to it. Some additional drag queen story time has been something that has been largely challenged across our country and including our state. In Multnomah last year, they had a drag queen story time scheduled, and there were so many protests outside of it that it actually ended up vandalizing the library to the point where they had to close the library and actually close the library staff inside until the protests would end. And that would be an example of a challenge, because the drag queen story time did not get to happen when it's unsafe for people to physically be in that area. Again, a reminder that Canby School District removed 30, or had a challenge for 36 books. Those 36 books were removed for up to 4 months while they did the review process, which again is an infringement on your rights, because you don't have access to those books for those 36 months while they're under review. And then where do challenges take place? Again, I've mentioned a lot of schools, so just another example of the books that were removed last year. In Napa School District, removed the book Flamer last year. But there are other ways that people are coming at libraries, and I want to call out Josephine County in particular, because that was a very interesting experience. So they had an individual that was challenging materials, and they appropriately upheld intellectual freedom, and they kept the materials on the shelves. That individual was so upset that they actually went up for library board and tried to get on the library board and influence it from there. That person they weren't elected, so they didn't get onto the library board. However, they found what they felt was a loophole in state law about special districts, which many public libraries across the state are a special district, including Deschutes Public Library, which means that we are paid through your property taxes. There's a clause in the special districts clause in our state that says that if your property is unable to receive services, that you can opt out of paying your property taxes. So this individual went forward to the county commissioners and attempted to opt out of paying the part of their taxes on their property taxes to not support the library. The commissioners said yes, which would have had a huge impact across the entire state of Oregon, not just libraries, but irrigation districts, fire districts, luckily not education districts, they're slightly separate. But they had to get a court opinion, the library had to pay to bring forward a court opinion to have that reversed, and legally reversed. So again, who are initiating challenges? And I just want to take us through the times when it's not parents or patrons. In Seaside last year, they had a city councilor, and this goes back to Tango Makes Two. This was one of the 3 books this individual was challenging, that was so upset about our penguins that he put forward a challenge report. Interestingly, challenge reports are FOIA-able, so and we should be able to know whether our elected officials are putting forward challenges to our public libraries. So we were able to find out that he was the individual that put forward that challenge report. The Seaside upheld intellectual freedom. They kept the materials, and he wanted to influence the collection development policy then. That, you're only keeping those materials because your collection development policy says that you have to. And it got so loud and so contentious that members of the community, members like you all, came forward and said, you know what, you're not fulfilling your responsibility as an elected official, so I'm gonna do a recall. And you have every right to try and recall your elected officials, and they did put a recall on the ballot, and that individual was actually recalled from office because of his actions towards the library on challenged materials. Grants Pass School District is in the middle, and actually I will tack on also 3 Rivers School District because they're right next to each other, of 9 book challenges right now. Grants Pass did remove 2 of those books, and they are trying to make sure that the school board, gets to be the ones that select all the materials, because of feeling like a librarian is incapable of making that decision by themselves. 3 Rivers School District seems to want to follow in their suit, so we are following that closely. And so then lastly, because I want to wrap us up, when this happens, the Intellectual Freedom Committee does put out statements to the public about our findings in these cases. So you can find that information on the Oregon Library Association website under their press releases if you want to follow that. We do try and get it out into news and media if the news and media will cover it, but news and media isn't always on our side. And if you ever hear about any incidences, please let us know. You can contact us from our toolkit, which is available on the Oregon Library Association website under committees, intellectual freedom, and we have a whole website dedicated to these types of resources. So if you need more information on how to prepare for a challenge or respond to a challenge, please go to the toolkit. There's a ton on there. And if you want to hear everything I just said, there's an hour-long video on the Deschutes Public Library's website that basically is a refresher of everything you just heard. What questions can I answer? Yeah.
Could you give us your understanding of the difference between the public domain and the private domain with respect to information? For example, why, for example, can Meta restrict content when, say, a public library cannot?
Yeah, that's a great question. So a private corporation such as Meta, such as any of our social media sites, they're a private corporation, which means that because we're a capitalist society, they can choose to sell or host anything that they want to choose to sell or host. So they have full reign to decide whether or not something is allowed or not allowed on their private, capitally based entity. Whereas we are a government entity, and so we are not a private corporation that is here to make money. We are a government agency that is required to uphold intellectual freedom.
So, for example, if Dutch Brothers Coffee said, I'm not going to serve black people, can they do that?
Possibly. So those types of cases have come forward. I vividly remember a case in Colorado that it was a wedding baker. They made wedding cakes, and they said that they wouldn't make a cake for an LGBTQ couple because it was against their religious beliefs. And I believe the courts held that you have right to religion and to refuse service. But that's where laws are at a disconnect, right? Because we also have laws that say you can't discriminate. And so a lot of it was like, well, that's discriminatory. It's breaking this state law, but then it's not breaking that state law, or the federal law, the First Amendment. And I think ultimately they said that the First Amendment right was protected above that anti-discrimination law. But it would have to be tied to that First Amendment right. So if that person's like, I don't want to serve black people, well, how is that your religious experience, right? Like, they would have to tie it directly, and it couldn't just be like, oh, I just joined it last week, right? Like, they would have to show true backing in that religion. So I think ultimately that would have opened the door to a discrimination lawsuit, and it would have to go through the courts.
Would that be, for example, would a media outlet, let's just take, for example, Fox News, not have an obligation to serve both sides of an issue because they're privately held?
Correct.
Got it.
Yes. Yeah, that's their freedom of press, where they can choose to share how they report.
For the cases that have succeeded in either restriction or removal, you mentioned that there can again be further lawsuits challenged by publishers, authors, and ACLU. How much are those challenges happening once the restrictions or removals happen?
Yeah, so to clarify, in order for the lawsuit to come forward, there has to be what's called an injured party. So in this case, if a book is removed from a school, it is the student who is the injured party. They had access to information that was then restricted. So that student, and often with their parents, if they're a minor, now if they're 18 in that school, they don't need a parent, which that's like our dream, by the way. Like, that's the perfect lawsuit. But that student and their parent, or an 18-year-old, would be able to sue the school district as an infringement on their First Amendment rights. And then what happens is then they contact ACLU, or they contact us, and we can get them in contact with the ACLU, and they back that student. So it's actually the student that's suing, but then you can add on additional hurt parties. So ACLU can't sue, the publisher can't sue, I can't sue, the librarian can't sue. You have to have that injured party, and then you can have secondary people sign on to that lawsuit. But it is happening. I mean, I think once you have someone brave enough, then I think a lot of people come forward, but they have to be very brave to be willing to do that, which is why here in Oregon, they're getting away with it. Because there's not been one student in any of these that has been willing to come forward. And I have contacts with all of these people, Penguin Random House and Pen America and ACLU, if we can find a student. But it takes extreme bravery to do that. And so they're getting away with it in Oregon. Like, that's just, yeah.
Couldn't a teacher be considered somebody who's harmed by that in the school?
They could do an employment lawsuit and then kind of tie to it and see if it could, so that might be more of a civil suit rather than a constitutional suit, but they certainly could say, you're infringing on my employment law, right? Like I am
you're
allowed.
also impinging on my, on my ability to teach the protected information.
Exactly. So they could sue it, but it would probably be through a different legal avenue. The other thing that they feasibly could do, and especially this would be, like a district librarian, is that the Oregon Constitution is actually really, really strong in freedom of information and freedom of speech. So they could say, if they told a district librarian, you're not allowed to buy books on this topic, they could say, you're making me break the state constitution. You're making me break the law in order to follow that. And so they could feasibly go that route. Yeah.
If an outside body established a particular piece of literature or pamphlet or something as being clearly disinformation, anti-scientific information or whatever, are libraries allowed not to place that literature or book on the shelf?
That one is complicated. So typically we are gonna look at a piece through many elements of our collection development policy. So one of those, like for Deschutes Public Library, even if that material is grossly flawed, if it is getting a ton of requests for purchase from our community or holds, like if Crook or Jefferson had it and there's a ton of holds, or there's like professional reviews for it, or it's been like the number of copies that are published at a certain threshold where they're expecting it to be purchased at a certain level, then we have a responsibility to still buy it because there's interest in our community to that information. So we would at times buy misinformation depending on how in demand it is to our community. It's a self-published book. Then we can turn to those resources and say, like, there's no information on this, we can't back anything on this, and then we have an area in our collection development policy that says scientific objectivity. So we could turn to it at that point. But there are times when we would buy misinformation. A really great example would be like during COVID. There were a lot of resources on all the different sides on like the COVID vaccine and what was going to happen and how dangerous this was and how dangerous it wasn't. But our community was interested in both sides of that topic. And so we had a responsibility to make sure that we provided that information to anybody that's interested. And one thing that I really like to share and make sure people are aware of is my favorite thing to read is something I disagree with. Like I read the COVID books that didn't fit my worldview because I want to know. I want to know what they're saying, right? So like there might be a ton of holds, and it might not be that that person has any interest in like affirming. Maybe they want to hear it because they read it because they want to like go talk to their parents about the arguments they're reading about and have an educated conversation. So that's where our responsibility often lies, is like we don't know why somebody wants to check that out, but they have a right to.
How do you choose the book that you put into the library?
Yeah. So again, we have selection criteria under our collection development policy. It, again, takes us through things like interest in the community, vitality, creativity, cost, things like that. We try and have it as objective as possible. But then we also really turn to those review sources. So if you remember the false advertising and then ultimately that data is published, it's published in what are called like Library Journal is a good one, or book list, but we get publications from the publishers that tell us these books are coming out. And we'll see things like, the reviewers are saying this book is really good or this book is really bad. So we'll look at that. We'll look at how many copies are being produced in the first run. So if like there's 3 million copies being produced, we're definitely buying it. If it's like 200, we're definitely not buying it. So things like that, we try and keep it as objective as possible so that, again, we're neutral in the materials that we're providing.
Emily, have you given this talk to the school boards in Deschutes County, Madras, Prineville, Lapine, et cetera? And also, have you given it to, I don't know, the equivalent of school boards in private schools, charter schools?
I love that. I'm kind of like a vampire, so you have to invite me in. So a lot of times the school boards don't want to hear this, right? Like it depends on where their political leanings are. For Ben Lapine in particular, they did last year, and I was able to share just individually with the superintendent some information and send some emails to the board. And they ended up protecting the materials, and it was fine. Redmond, I work with one of the school board members, so Liz Goodrich works for the school, and
She's also leading.
yes. So her and I are very well versed together, and she has heard this talk more times than she even knows. So she knows that the door is open if the rest of the school board is ever interested in having me come. I have not talked with anyone from Jefferson, although Jefferson and Crook Public Libraries share our online catalog, so we have an agreement with them. And again, I've mentioned to them many times that I'm happy to come and talk with their staff. At Crook, they did have an issue about 2 years ago now, where the school board, the library board, the public library board, wanted to label all of the LGBTQ materials in the kids section as LGBTQ and give it a separate shelving location. And it got very heated. But I did go to that particular board meeting, and luckily at that board meeting, after hearing from me and hearing from administrators also at Deschutes Public Library, they did not move forward with the relabeling of those materials. So that was a few years ago, and I think there might be some new board members, but I try and get it out as much as possible. I did present to the Three Rivers School Board last night. If you're really interested in something, I would highly encourage, once those meetings are up on their YouTube, you should go see that, because that board did not want to hear that, but the superintendent made sure I had space. And so if you want to see a spicy board, that's a good one to go to. Yeah.
What about private though?
I have not, but I'd be happy to, and my door is always open.
Okay,
Yeah.
let's just do one or two more questions because we're way past our time and we could probably talk about this for hours.
I know, yeah, go for it.
How about the Naval Academy removing 600 books before HAGSEF?
Yeah. So
Pardon me?
the Naval Academy removed, was it 300 or
600.
600
So it
books?
depends what you read, but.
Yeah. So there's executive orders that have been happening. I don't know if you guys know about them. So one thing to know, and again, I think I'm preaching to the choir a little bit, but an executive order is not law. It does not change any of the laws that we have to follow. The executive order does, it is essentially the business owner, i.e. the president, telling its employees what they're allowed to do, their process and procedure, and control the money. So when that executive order comes through, if you don't need that money, then you don't necessarily have to follow it. So, okay, take our funding. You haven't changed any laws, which is exactly what's happened, by the way, at Deschutes Public Library. Again, thank you for your property taxes. You protected us from the need for federal money. So we will continue forward. But for the Naval Academy, they do require that federal funding, and those are federal employees. So under the executive orders, they had to follow that. And actually, the same thing happened just last Friday. The Institute of Museums and Library Science Services was shut down entirely, and that one's questionable because it's actually written into law that organization exists, but that will have to go through the courts for them to get reinstated.
One more,
Last
one more.
Last one.
Yeah, we're back here.
I see you.
Okay. Actually, this was similar to the question you just responded to. What about the government removing information from publications and public spaces? And I was thinking more in terms of public libraries.
Mhm.
And there are some public libraries that are repositories for all federal and state documents.
Yeah, that's terrifying. And they, right now, again, it will have to require a court case for that behavior to stop. Right now, if they're federally funded, they do have to follow the, executive orders. However, there are a lot of private, our other public universities that are trying as best as they can to archive things as fast and as quick as they can. So I know that like New York Public Library, Boston Public Library, our big academic libraries are trying to grab some of that data while they can. But right now, yeah, it can go.
So if they're archiving it, they put it somewhere. And
And again, if they're not federally funded, then it's protected.
Well, I don't know what to say after that. There was an incredible amount of information, and I think I'm going to watch your other video and relearn what you just told me.
Yeah.
Thank you so much.
Thank you.